All right, let's dive right in. The title for today's explainer sounds, well, kind of impossible, right? The unconstitutional Constitution. It's a total paradox. But believe it or not, this isn't just some clever brain teaser. It's actually one of the deepest, most challenging questions in all of constitutional law.
So let me ask you straight up. Can a constitution be unconstitutional? I mean, think about it. Can a country follow its own rulebook, word for word, to pass an amendment, and then have that very amendment be declared unconstitutional? It feels totally circular, doesn't it? Like the rulebook is breaking its own rules. But this isn't some philosophical game. This exact question has sparked massive legal and political fights all over the globe.
And hey, if you think this is just for law nerds, get this. The famous mathematician Kurt Gödel, one of the smartest people of the 20th century, was studying for his U.S. citizenship test after he'd fled the Nazis, and he found something that terrified him. He was convinced he'd discovered a loophole, a way the U.S. Constitution could be legally amended to turn America into a dictatorship. He was so freaked out that his buddy Albert Einstein literally had to go with him to a citizenship hearing just to make sure he didn't blow it by arguing with the judge. Now that shows you the stakes. Gödel's fear is exactly what we're talking about today.
Okay, so here's our game plan to unpack all this. We're going to start with this constitutional puzzle. Then we'll jet over to Ireland to see what happens when the people's power is absolute. After that, it's on to India for a completely different take, the basic structure doctrine. Then we'll get a bit philosophical and ask, what even is an amendment? And finally, we'll wrap up with a judge's final dilemma. Let's get into it.
All right, first up, Ireland, and the case for unlimited power. The idea here is really straightforward. What the people want, the people get. Their will is sovereign, and the courts, well, they just need to get out of the way.
Let's get right into a really, really shocking case. State versus Ryan. So, back in the 1930s, the Irish government passes this amendment disguised as a Public Safety Act. But this wasn't some temporary thing for an emergency. No, this gave the government the permanent power to create military tribunals that could hand down the death penalty without any due process. I mean, think about that. One of the dissenting judges called it the antithesis of the rule of law. They basically used the amendment process to delete some of the most fundamental rights in their own constitution.
So you're probably asking, how on earth did the court let this fly? Well, this quote right here is everything. Justice Fitzgibbon's logic went something like this. Look, every single thing in the Constitution is there because it's considered fundamental. If it wasn't important, it wouldn't have made the cut in the first place. So who are we as judges to start saying, oh, this article is super duper important, but that one is only kind of important? He said you just can't do that. As long as the government followed the rules for making an amendment, it's a valid amendment, period.
Okay, so you might think, well, that was then. Maybe things changed when Ireland got a new constitution in 1937, one that said amendments had to be approved by a popular vote, a referendum. Now it's not just politicians, it's the people themselves making the change. Surely that changes the court's mind, right? Nope, their stance stayed exactly the same. Decades later, in a totally different kind of case in 1995, the court basically said our position hasn't changed one bit.
And this quote just hammers the point home. It perfectly captures the Irish legal philosophy here. The will of the people, when they vote in a referendum, is sacrosanct. That's a powerful word. It means it's holy, untouchable. Once the people have spoken, that's it. Game over. No court gets to second-guess them. So in Ireland, the power to amend is absolute, unlimited. End of story.
Okay, now I want you to completely flip your thinking. We're heading to India, where a massive constitutional crisis led to a totally revolutionary idea. The idea that, yes, there are limits to what you can do with an amendment.
And man, the backstory here reads like a political thriller. Seriously, it starts in '67 with the Golokanath case, where the Supreme Court says Parliament can't mess with fundamental rights. Well, this kicks off a huge power struggle. Prime Minister Indira Gandhi basically goes to war with the court. In '71, she wins this massive election, and her first move is to pass amendments to put the court back in its place. This all comes to a head in '73, in the legendary case of Ananda Party case. This is where the court fires back with the basic structure doctrine, and the fight doesn't stop there. By '75, Gandhi declares a state of emergency and passes amendments to make herself basically immune from the courts. It was an absolute wild time.
So what is this basic structure doctrine that came out of all that chaos? Okay, for all of you law students prepping for exams, lean in, because this is the key takeaway. The doctrine says that every constitution has, well, a soul, a core identity, an essential framework. And while Parliament has the power to amend the Constitution, it does not have the power to destroy that core. The power to change is not the power to obliterate. It's a brilliant, powerful idea.
Now, the court has been pretty clever here. They've never given a final, exhaustive list of what's in the basic structure. They've kept it flexible. But over the years, they've given us a lot of hints. Things like the supremacy of the Constitution itself, the idea that it's the highest law, a democratic and Republican government, the secular nature of the country, separation of powers, federalism, the principle of equality. You can think of these as the load-bearing walls of the entire constitutional building. You can repaint the rooms, you can move some furniture, but you cannot knock down those walls. This whole idea was really locked in place with the Minerva Mills case in 1980. The court looked at these amendments passed during the emergency, the ones designed to make Parliament all-powerful, and they struck them down. And their reasoning came down to this incredibly powerful line: the power to destroy is not a power to amend. They're saying, look, you are given a chisel to make the sculpture better, not a sledgehammer to smash it to pieces. Using that power to destroy the Constitution's identity isn't amending it, it's killing it. Okay, so we've got Ireland saying anything goes, and India saying, hold on, there are limits. This contrast really pushes us to ask a much deeper, more philosophical question. What is an amendment anyway? What does that word even mean? Does any change count as an amendment? Or is there a point where a change is so huge, so fundamental that it stops being an amendment and becomes something else?
You know, Abraham Lincoln actually drew a really important line in the sand on this. He talked about two different rights the people have. First, their constitutional right to amend, but second, their revolutionary right to dismember or overthrow the government. See the difference? Amending is working within the system. Overthrowing is destroying the system and starting over. And what the Indian Supreme Court did, in a way, was take Lincoln's political argument and turn it into a concrete legal doctrine. They said an amendment can't be a revolution in disguise.
And if you want the philosophical DNA for this idea, you've got to look at the philosopher Edmund Burke. He had this beautiful way of thinking about a nation. He said it's not just about us right now. It's a partnership between generations, past, present, and future. So for Burke, a constitution isn't just a document. It has an identity, a character, shaped by history. And the whole point of making changes, what he called reform, is to preserve that core character. It's like gardening. You prune a tree to make it healthier and stronger. You don't take a chainsaw to its tree. And this right here, this quote from Justice Khanna in the case of Ananda case, this might be the single most important sentence in this entire area of law. If you're studying this for an exam, memorize this. He says the word amendment itself assumes that the old Constitution survives. It has to survive without loss of its identity. You can change it, sure, but it has to remain fundamentally itself. If you change it so much that its core identity is gone, you haven't amended it. You've replaced it. It's an act of abolition, not amendment. So this all brings us to the final showdown, the core dilemma for any judge facing this problem. It's a clash of two huge ideas, the absolute power of the people versus the enduring identity of the Constitution. This chart really lays it all out, side by side. You've got Ireland on one side. Their core principle? Popular sovereignty. This means the judge's role is to be deferential, to step back. And the result? Amendment power is absolute and unlimited. Now look at India. The core principle isn't sovereignty, it's constitutional identity. This makes the judge a guardian, not just an observer. And the result? The amendment power is limited by that basic structure. It's really two fundamentally different ways of looking at the same problem. But let's pull back for a second, because there's a really sobering thought we need to consider. It comes from the great American judge Learned Hand, and he basically warned us not to put all our faith in courts and constitutions. He said if a society has gone so far off the rails that the spirit of moderation is gone, if people are just determined to tear everything down, no court, no judge, no legal ruling is going to save it. He's suggesting that at the end of the day, law itself might be helpless in the face of pure political will.
And that brings us to our final and maybe most troubling question. Think about it. The Indian Supreme Court had to step in to save its constitution from the people's own elected leaders. So if a court has to play hero and rescue the Constitution from the democratic process itself, does that mean the spirit of moderation Judge Hand talked about was already dead and gone? And that's the ultimate paradox, isn't it? Can a legal document enforced by a handful of judges really save a democracy that no longer seems to want to save itself? It's a tough question with no easy answers.